It is essential that governors have a good overview of the admissions process and the admissions appeals process. In this video, we will cover the basics for governors. In terms of admission to a school, parents may express a preference for the school at which they wish their child to be educated. This must be complied with unless that would be prejudicial to efficient education or the efficient use of resources. There is always a right of appeal against a refusal to admit, and reasons for refusal must be given. The purpose of the Admissions Code is to ensure that school places are allocated and offered in an open and fair way. The Appeals Code is designed to give admission authorities the freedom they need to run the appeals process efficiently, whilst maintaining minimum requirements which will ensure fairness and transparency. For governors to sit on an admissions appeal panel, they must be trained in a number of areas. The law relating to admissions, duties under the Human Rights Act 1998 and Equality Act 2010, procedural fairness and natural justice, the roles of particular panel members, for example chairing skills. An appeal panel must consist of a minimum of 3 members. That's including at least one lay member without personal experience of school management or provision of education, except as a governor or volunteer of another school. At least one member with experience in education, familiar with educational conditions within the LA, local authority, or parents of a registered pupil in another school. There is no upper limit, and the chair has casting vote if necessary. No one may sit on an appeals panel who has or has had any connection with the local authority, or the school, or any person other than a teacher employed by the local authority or the governing board. The regulations also prohibit anyone where doubts about that person's ability to act impartially could be implied. Admissions authorities must set a timetable and publish it on their websites by the 28th of February each year, which gives at least 20 school days to lodge written appeal, gives at least 10 school days notice of a hearing date, and includes reasonable deadlines for submitting evidence and sending papers out to everybody on the panel. Must also ensure that appeals are heard within 40 school days of appeal deadline in the normal admissions round, or 30 school days from lodging appeal in other cases. The participants that can be expected to attend an appeals panel include the chair, the clerk, the presenting officer, the parent, also referred to as the appellant, a parent representative, and other panel members. The chair of the admissions appeal panel would be expected to set the tone, as relaxed and informal as possible, but consistent with the importance of the hearing, is responsible for the conduct of the hearing, introduces each party and explains their roles, explains procedure, ensures good order and controls debate, and makes sure that parents have a full and final hearing. In addition, the chair should lead the decision process after the hearing. The school must provide a presenting officer to present the decision not to admit a pupil and to answer detailed questions about the case. The school will previously have provided documentation showing how the admission arrangements and the coordinated admission scheme apply to the appellant's application. The reasons for the decision to refuse admission. How admission of an additional child would cause prejudice to the provision of efficient education or resources. No later than 10 school days before the hearing, the admission authority must provide appellants with written notification of the date of and arrangements for the hearing. The notification must include a deadline for the submission of any further evidence that was not sent with the initial appeal. Admission authorities must inform appellants that any information or evidence not submitted by the deadline might not be considered at the appeal. Admission authorities must ask appellants whether they intend to call any witnesses or be represented at the hearing. Parents may waive their right to 10 school days notice of the hearing. It is essential that governors read the papers and the Code of Practice before the Admissions Appeal Panel hearing. Governors should also consider whether specific questions should be asked by particular members of the panel. It is also vital that if a governor recognises an appellant, that they consider disqualifying themselves from the process swiftly. The suggested order for a hearing is that the case for the school is presented. Parents and the panel can then ask questions, although this may be done as one big group. The case for the parent is presented, and the school and the panel are given opportunity to ask questions. The school sums up its case, and then the parent sums up their case, and it's important to ensure that they always have the last word. To find out more about your responsibilities as a governor with regards to admissions appeals, including multiple hearings and the matters panel members should consider during the appeals process, please access our training package. This can be found at www.servicesforschools.org.uk.